All right, good morning, good afternoon, good evening, whatever time you are watching this quick video. I am Angie Holloway and I am the lawyer for doctors. In this video, I am going to share with you the top 4 risks for Georgia medical practices. All right, so let's get into it. What are we going to be talking about in this few minutes, right? So we're going to talk about recent Georgia Medical Board discipline cases, recent medical malpractice cases, and the top way to protect your practice, which is, spoiler alert, your patient services agreement. All right, for those of you who don't know me, my name is Angie and I am the lawyer for doctors. We help top Georgia medical practices protect their licenses, their practices, and their peace with concierge legal expertise that allows you to focus on providing exceptional patient care. All right, so let's get into it. The top 4 risks for Georgia providers. Number 1, inadequate patient care. Number 2, improper delegation of duties. Number 3, compliance errors. And number 4, employment matters. Now, employment matters are not going to be the primary scope of this quick video, but I'll mention it briefly before we conclude. All right, so recent Georgia Medical Board discipline cases. So one of the first things I want to bring to your attention is that the Georgia Medical Board has disciplined 5 times more providers in the last couple years than it did in the several previous periods, all combined. So as you'll see on this screen, in 2018, only 34 medical providers, including providers outside of just MDs, were disciplined. If you look at the 2022 stats, over 142 providers were disciplined, and in this year alone, 49 providers have been disciplined. So what do we gather from those disciplinary records? The top 3 reasons for discipline of Georgia providers is number 1, inadequate patient care, number 2, improper delegation of duties, and number 3, compliance issues. So looking at the first reason, inadequate patient care, from looking at the actual orders from the GMB, the most common theme that I see there is too high patient caseloads, inadequate operational measures, and inadequate record-keeping procedures. So most of the time, the fact patterns of these MDs or these providers is that they had too many patients, they weren't allowed to do the records properly. Maybe they ended up allowing a nurse or a physician assistant to do something without supervision, and it resulted in some kind of negative outcome for the patient. The patient has complained. Maybe there was some kind of minimal issue. Maybe they changed providers altogether, or maybe it resulted in some kind of major medical emergency that wasn't diagnosed, which we'll talk about in just a second in these med-mal cases. And lastly, compliance issues. So failure to renew on time, failure to complete CMEs, all these different things that you have to comply with on a biannual or annual basis, and they were not completed. For example, one provider continued to prescribe prescriptions, although he had lost his medical license for failure to renew it. All right, so what happened to these providers? The real cost of failing to have some kind of compliance protocol in place to protect your license, your practice, and your peace, some of these providers lost their medical license permanently. Some were put on restricted license for 6 to 18 months. Some had to pay fines of up to $20,000, and some had to be supervised by other providers and complete additional CMEs. All of these specific outcomes that I'm referring to can be read, of course, as always, on the GCMB website. All right, so let's look at some recent medical malpractice cases. In 2024, a recent $8.5 million verdict for a plaintiff after a physician failed to diagnose appendicitis in a timely manner. Just last year, there was a $60 million verdict for a plaintiff against a doctor who prescribed antidepressants and failed to disclose the suicidal ideations that could result from taking that medication and did not have adequate monitoring in place. So these compliance mechanisms that we're talking about as far as being a huge risk for MDs and providers in Georgia, making sure that you have, for example, ticklers in your HIPAA compliant portals that allows you to follow up with a patient and monitor them, and that can help you to avoid situations such as these. All right, just a few months ago in August of 2024, there was a $47 million judgment med mal case. In Georgia, the highest medical malpractice judgment to date is $75 million. All right, so how can we help you protect your practice? The first thing that we do is we create a custom strategy to address your top risks, which is number one, protecting your license, and number two, protecting your practice. The first step of that compliance protocol is to audit your patient services agreement. All right, so when you book a patient audit agreement session, what we will do is we are going to look at the current protocols you have in place. A lot of times I see MDs that just have a HIPAA form. A HIPAA form is not enough to protect your license, your practice, or your peace. So these are some of the top things we're going to be looking for. Do you have ADR terms, indemnification terms, attorney fee provisions, a communication policy that includes HIPAA protocols? And so the important nuance here is that, for example, if you have a patient that emails you some sensitive patient data and your email, for whatever reason, is hacked, now you have something that has occurred that could have been prevented with a policy in your patient services agreement, right? So you want to have indemnification, which is a shifting of the risk from yourself and your practice to the patient in the event that they would send sensitive information to you via email. So this is just one example of one of the protocols that we're looking for in your patient services agreement, which is your primary contract that you're going to be using for any patients that you serve. We're also going to be looking for risk waivers, notice and acknowledgments for certain types of drugs that you may be providing to patients, payment and collection terms, not just a promise to pay, right? So if you're relying on insurance reimbursements, of course you want your patients to agree to pay in the event that they deny the claim. But if this is a large amount of money and you want to initiate collection procedures, do you have collections language to enable you to do so, to report it to credit bureaus, etc.? And there are so many more that I will not be able to go through in the context of this quick little 7 or 8 minute video. All right, thank you so much for taking the time to watch this. Again, my name is Angie Holloway, and I am the lawyer for doctors. If you are ready to submit your appointment request, you can click the Calendly link below and schedule it. Remember, if for any reason we're not able to provide you with at least 3 actionable things that you can use to increase the protection in your patient services agreement, you can request a refund of your session, and we will provide a 100% refund to you within 7 days of your request. Thanks so much. We look forward to working with you. Talk soon. Bye-bye.